Here we go. All right. Well,
Okay.
welcome everyone to episode 29 of the FCPA Compliance and Ethics Report. I'm absolutely thrilled today to have my good friend and colleague, the FCPA professor, Mike Kohler, with us. We're going to do a two-part episode, so it will be episodes 29 and 30. This will be part one. I've asked the professor to talk about some of the things that are on his mind, and as usual, he's got some excellent points that we hope to be able to go into in some depth. For those of you who don't know the professor, he blogs daily at the FCPAprofessor.com, and what I've found is he definitely sharpens your skills in the debate. So if you hear anything that interests you, my suggestion would be that you email him and engage in an email discussion or debate with him. The thing that I really like, as you may guess, since he's a professor, he always seems to come back to the question, whether he says it or not, is what is your authority? And I find that incredibly refreshing. Your authority may be cases, it may be case law, it may be the statute, it may be the underlying congressional debate on the statute, but he always comes back to what's your authority. And that's something that certainly as a lawyer I appreciate, and it'll certainly hone your skills as a debating partner. So with that, Mike, I really appreciate you coming on today. I hope to have a really interesting visit with you. You've sent me some topics that are on your mind, and I don't know if I have them all in the right order, but perhaps we can start with some of the comments of Mary Jo White, who's the current commissioner of the Securities and Exchange Commission. What have you found interesting that she's talked about lately?
Yeah, first of all, thank you, Tom, for that kind introduction and having me on your program again. The last quarter really has been an active quarter in terms of enforcement agency officials giving speeches, including both specifically on the FCPA and more broadly just as to important public policy issues which impact the FCPA as well as other areas of law. One speech by Mary Jo White that I found particularly relevant was her speech that focused on the importance of trials and how trials are a bedrock principle of our democracy, how trials facilitate the search for the truth, how trials hold government enforcement agencies accountable. All spot-on comments, of course, but the irony is that the SEC has come up with policies and procedures, whether by design or not, certainly have had the effect of making trials very, very rare in their enforcement actions. And when you take these comments and you apply them to the FCPA context, you lead to the undeniable conclusion that when the SEC is put to its burden of proof in FCPA enforcement actions, they have an overall losing record. So I know that Mary Jo White's comments were not specifically dealing with FCPA enforcement, but I found it very relevant that here she is, the most notable figure in the SEC right now, talking about the importance of trials, when in the end of the day there are very little trials, and at least in the FCPA context, when there have been trials, they have not prevailed.
Very interesting observation, and I'd like to comment that from a little bit different angle. First, I would say that I certainly agree with your opening comments about the importance of trials in a democratic society. But I would add that it's important to have trials because it's important to test laws, and it's important that trial judges interpret laws, and that those interpretations by trial judges go up to higher levels of authority within the judicial system for further review and interpretation. And I think one of the things that we have both talked about in our social media blogging career is really the dearth of case law in the FCPA realm. And if there were more cases, more trial judges interpreting the FCPA, and certainly more courts of appeals interpreting the FCPA, perhaps even as high as the Supreme Court, the case law would be more well settled. One of the things that I think frustrates companies is not knowing what the judicial interpretations of the FCPA are, simply because there haven't been a lot of judicial interpretations. So I would add that as another particular reason why going to trial is a good thing. We are both recovering trial lawyers. I practice more on the civil side. I believe you were more of a white-collar defense lawyer, so we may come at trials from a little bit different angles in terms of civil versus criminal. But certainly in the civil trial world, it is important that people have their day in court, whether those people are plaintiffs, whether those people are defendants, whether those people are corporations, whoever the parties may be. So I would also add that actually having your day in court is important, and that really leads me into the point I wanted to raise with you, or at least discuss further, which is that the SEC perhaps has not been as successful when they've gone to trial. I would say from a defense lawyer perspective, once again from the civil side of things, that if you're going to lose, you don't go to trial. You settle the case. And the people that go to trial against the SEC are generally individuals, and I would say probably with the Department of Justice as well in the FCPA context. And they're looking at some serious jail time and some serious negative consequences to their lives, their liberty, and their freedom. And they may find themselves in a position where they're willing to go to trial and they're willing to push the government. I am not offended by that. I think it's appropriate. I think it's appropriate that the government is put to its test. But it doesn't surprise me to have a less than sterling winning record by going to trial. As we would say in Texas, if you ain't lost a case, you ain't been to the courtroom. So that really doesn't offend me that the SEC has lost cases at trial.
Well, Tom, I'm just obviously commenting specifically about FCPA enforcement, recognizing that the SEC obviously enforces many laws. But my concern, though, is the fact that the SEC themselves is directly responsible for the dearth of case law because of the settlement resolutions and policies they have created and indeed have championed. Prior to January 2010, when the SEC announced these new cooperation tools, including DPAs and MPAs, there was already a dearth of trials because of the SEC's neither admit nor deny settlement policy, which has been tweaked along the margins in the last couple of years, but essentially remains largely the same in many cases. And now you also have the SEC championing use of non-prosecution and deferred prosecution agreements, not just in the FCPA context, but they've been used there and in other areas as well. All these vehicles are going to do is further make it less likely that there is going to be a trial and an adversary system to flesh out what various securities laws means. So it's highly ironic in my mind that on one hand, Mary Jo White champions the importance of trials, how they're important for many of the reasons I mentioned and you rightly mentioned as well, yet at the same time having policies and procedures that they champion that make trials less likely. And I mean, in terms of sort of your opening point, I think it's important for people to recognize the difference between legal authority and non-legal sources of information, particularly when it comes to the FCPA. Resolved enforcement actions, whether via NPAs or DPAs or neither admit nor deny settlement actions, that's not legal authority. That's non-legal sources of information. And of course, the compliance community and the corporate community needs to pay attention to these non-legal sources of information. But at the end of the day, it's not legal authority in the least bit. And the few number of instances in which the DOJ particularly has tried to cite to its prosecutorial common law in FCPA cases, the judges have basically said, you got to be kidding me. That's not legal authority, it's a non-legal source of information. And I think there is so much disconnect in the corporate community as to what legal authority says versus what non-legal authority and other sources of information say. In many cases, there's a disconnect.
Well, you raised a couple of interesting points. The first one on the types of resolution documents, or excuse me, resolution procedures that the SEC has developed, which may even lead to less trials. I guess I see a dynamic tension there, tension between going to trial, as Mary Jo White talked about, trial is the cornerstones of a legal system, and the reasons that we articulated, with having an enforcement agency with a wide variety of tools that it can use. I understand it's a tension, but I think that's a tension that can coexist together. As to really the second point, you're absolutely right. It's not legal authority. It shouldn't be cited as legal authority, although you and I and others perhaps bandy it about where people who may not understand the nuances of it may think we're discussing legal authority. And that probably would lead to an entire episode just on that issue alone. Where do people come up, or where can the public, a practitioner or a corporation or anyone else go to for solid information? And I think that's that's one of the things that we both continually talk about, is the lack of real legal authority. But your point is absolutely well taken. They're certainly interesting, they certainly provide guidance, but they're not legal authority. They can't be used or they shouldn't be used in citations, and they shouldn't be used in court cases going forward. They're just basically commentary. But unfortunately, that's what we have.
Well, right, but the reason we have it is because of the enforcement agencies themselves have created these vehicles and have championed them. They themselves are at least in part responsible for this dearth of authority that is out there. One of the most meaningful statements I think I've seen an enforcement agency official make was a couple of weeks ago at an FCPA event where the SEC's co-director of enforcement stated FCPA law is not well developed. That was a very meaningful and notable and candid statement. Tom, another thing I'd just like to return to very briefly is this whole notion that you frequently hear SEC officials say, and that is we need these alternative resolution vehicles so that we can be more efficient, so that we can be quicker, so that we can resolve this matter and go after the next matter to best protect investors. The SEC is a law enforcement agency. You show me anything in the Constitution or other legal authority which says that it's supposed to be quick and it's supposed to be easy for a law enforcement agency to bring criminal or civil charges against a person, whether it's a legal person like a corporation or other business organization, or whether it's individuals. It's not supposed to be easy. There is burdens of proof. There are speed bumps that our founding fathers put in this process to best protect individuals against an overreaching government.
I guess having efficiencies in enforcement is not something that really offends me. Is it in the Constitution? No, but it's not in the Constitution either. And I really don't see the SEC typically, at least in the FCPA world, bringing criminal penalties or criminal sanctions or criminal actions which would invoke the constitutional protections. Unfortunately, we don't have those constitutional protections on the civil side of things. So I guess I see efficiencies and you see something else.
I mean, I would disagree with that. Obviously, the SEC is a civil law enforcement agency, not a criminal law enforcement agency. But read the Supreme Court case in SEC versus Gibaldi concerning statute of limitations. A unanimous Supreme Court recognized that the SEC is not just any civil litigant. It's a government enforcement agency with quasi-criminal civil enforcement powers, and I think there's a growing movement in recognizing that the SEC is not merely a civil litigant.
Well, let me just end our discussion about trials at this point, because I want to move into one of the areas that you did mention, which was the SEC official talking about the case law is not well developed. And let me just start off by saying, is that a surprise? I mean, everyone knows that. Why, I don't understand the reason you put such significance to it. It's not that it's an insignificant statement, but I think, to me, it was just reiterating what we already knew.
Well, yeah, and I began my post on that issue by saying it's an obvious statement that is known and understood by many, but it came from the co-director of the SEC's Division of Enforcement. So here we have a situation in which both the SEC and the DOJ are aggressively talking about their FCPA enforcement programs, are on a moral crusade to rid the world of bribery and corruption. And yes, they have spoken about their FCPA enforcement program in those religious terms. And oh, by the way, the law is not well developed. If you don't see any inconsistency or logical gaps in that, I encourage you to do so, because I think it's a highly relevant statement coming from the SEC's co-director of enforcement. And I agree, we all knew that. But by the fact of who it came from, I think is what makes it meaningful.
Well, I guess to me, I hate to quote Howard here, but water is wet, and I think that statement kind of was close to that. It was really just, for me, stating the obvious.
Have you ever seen, though, another statement by an SEC or DOJ official about its FCPA enforcement program that you would put into that category?
Stating the obvious?
No, not stating the obvious, but saying FCPA law, legal authority, is not well developed.
I guess I've not heard the DOJ say it with that specificity, but once again, it seems to me just stating the obvious, so I'm not offended one way or the other by it.
Well, I'm not offended by it. I simply highlighted it because I think it is the most notable statement by an FCPA enforcement agency or official in this new era of FCPA enforcement.
Okay. Now I'd like to turn to Judge Rakoff. We both wrote about his speech. I was frankly stunned to see a sitting federal judge make, I don't know if there were controversial statements, but certainly very strident statements about what he viewed on some enforcement actions. I read about it on the front page of the Financial Times out of London, and it created such a stir that it was reported on the front page of that publication. But he really went after, in a very strong language, both deferred prosecution agreements and non-prosecution agreements. I think you may have his exact language, but he found them, I believe, morally indefensible. Maybe you have those exact words, but he really criticized the department and any of the agencies that might use those. What did you get, or what did you draw from his remarks?
Well, I've long admired Judge Rakoff for being a leader on some of these white-collar criminal law enforcement issues. So hats off to him again for, again, probably stating the obvious, but the fact of who it came from is what makes it meaningful. Now, the direct focus of Judge Rakoff's comments was the lack of individual prosecutions and the accountability for the so-called financial crisis. So just so listeners are clear, he was not directly talking about FCPA or FCPA enforcement. And I think Judge Rakoff was spot on in the sense that he basically asked the rhetorical question of why are so few individuals charged in connection with financial crisis related cases. And he said there's a number of factors that could potentially be at play, including the fact that notwithstanding that a company, for reasons of risk aversion, may enter into a DPA, no fraud perhaps may have occurred. Now, next, Judge Rakoff, I think, in very nice language, stepped through how the game is played, and it truly is a game, when a DOJ prosecutor is going after a criminal, a corporate entity for alleged improper conduct. Judge Rakoff said, quote, in practice, the use of MPAs, DPAs, and this whole game has led to some lax and dubious behavior on the part of prosecutors. As you noted, he called use of MPAs and DPAs, I think he was more focused on DPAs, as being both technically and morally suspect. So I think, obviously, given his position, he's not just any federal court judge. It's Southern District of New York in a very high-profile judicial district. But I'll just relate this back to what I've been writing about for years, Tom, and that is when you have a case that is resolved, FCPA case, resolved solely with an MPA or DPA, right? There's an 83% chance there will be no individuals ever prosecuted in connection with that underlying conduct. In contrast, when the, I think I got my numbers mixed up there. When an MPA or DPA is used to resolve an FCPA case, there's only a 6% chance that any individuals are going to be charged. Whereas when the DOJ uses a plea agreement, there's an 83% chance that an individual is going to be charged. There's this massive gap there. And I think it's very meaningful, and I think it's a very relevant data point which suggests that MPAs and DPAs do not necessarily represent instances in which provable FCPA violations have occurred. And a federal court judge, high-profile one at that, raising very similar issues in a different context, I thought was very meaningful.
I certainly agree with your last statement. Early or throughout your remarks, you, I believe, characterized the process as a game. I don't think it's a game. I really think it's a process. And I think to call an investigation and negotiation and a resolution a game really takes away from both the prosecutorial side and the defense lawyer side. So I would just have to challenge you on that point. You have talked about certainly the lack of individual prosecutions, and it's something that I've thought about a lot in terms of who is in the best position to make the change. Is it prosecution through settlement mechanisms with corporations? Is it prosecutions against individuals? I have to say I've not come out with a clear answer on that, but the statistics you raise, I think, are very telling about the number of corporate prosecutions versus individual prosecutions, although I think we've had a series of individual prosecutions this year that perhaps is beginning to answer some of those questions. The point we both started with was that this is Judge Rakoff, and the respect that we both have for him is obviously very high. My former colleague Howard Sklar practiced in front of him, and his appreciation and respect for the judge was even higher than ours, having practiced in front of him. So when you have a sitting federal judge making comments about, yes, it was the financial crisis, but he's sitting at the center of prosecution of the financial crisis, which is in the Southern District of New York, I think it's something that everybody needs to sit up and listen to, whether that everybody includes people like you and me, whether it should include white-collar defense lawyers, it should include the prosecutorial bar at the Department of Justice and other enforcement agencies, and I hope that it will lead to a continued discussion, and when we can get federal judges discussing it, I think that's where some real change may take place.
Now, Tom, just because something's a process doesn't mean it can also not be, in many respects, also a game. So, resolving an FCPA enforcement action via a DPA and an MPA is not exactly a search for truth. It's not exactly a search for accountability. It's not exactly a process that allows for mitigating facts to be considered by someone other than the enforcement agencies. It is, at the end of the day, a game. It's an important game. One of the players possesses a very sharp stick. But at the end of the day, resolving FCPA enforcement actions is, in many cases, I'm not suggesting all cases, a game where the primary motivating factor is efficiency. The primary motivating factor is certainty. And that's not things we normally associate with a legal process.
Well, coming out of the corporate world, I would say certainty is something the corporation always values. And I really don't think it's fair to call it a game. Anytime I went before any sort of enforcement agency or prosecutor. I didn't think it was a game. I don't think they took it as a game. I agree it's a process. There are steps that each go through. Those steps could be different than the steps that would go through at trial, but I don't think the process itself should be demeaned by calling it a game, and I guess that's the point.
I don't know that that's a demeaning term. It's certainly not intended to be one. It's calling a spade a spade. I mean,
well, perhaps we just have to disagree on that part. But with that, Mike, I think we're probably at the end of part one. So I would tell our listeners that we will have part two of my interview with the FCPA professor. I hope that you will consider the things he said and do what I've done, which is engage him in an email debate. It is a ton of fun. So with that, I'm going to bid you adieu, and I'll call you back for part two.
Sounds good. Thank you.